up next, we have a panel that's going to be talking GCD accountability. GCDs are held accountable in a variety of ways. There are local mechanisms through the courts. The development board, has approval of management plan, a role there. We also have legislative oversight. The state auditor reviews GCDs and their accomplishment of objectives and their finances as well. And then there's TCEQ, who's empowered with oversight responsibilities. And this past year, we saw that oversight in action through a petition for review that was filed and considered by TCEQ. So that's what we're going to be hearing about with this next panel. I'm going to kind of stop there and just introduce our moderator to introduce the other panelists. I'm pleased that Bill Dugat, managing partner at Bickerstaff, Heath, Delgado, and Acosta, is moderating this panel. He was involved in this petition, as are all the panelists, so they really provide a great perspective to have this discussion. If we could get our panelists' cameras up, that would be fantastic.
What we want to talk about today is I'm going to give a brief overview of the different accountability options that are available statutorily involving the GCD, and then we're going to spend most of our time talking about the petition for review and the specific case of the petition review that was recently progressed through the commission. So statutorily, there are, I'm trying to get my screen going here. Statutorily, there are 3 accountability provisions in the Water Code. One is if there's a management plan that's not submitted, there's failure of a district to submit a management plan, the TCEQ can initiate an accountability process. There's also the state auditor process where GCDs are audited at least once every 7 years and within a year of incorporation of their management plan. I suspect that everyone in the audience, GCD members, have had their GCD audited by the state auditor. And then the final is a performance review that is conducted through the initiation of a petition for review or petition of inquiry. If you can go to the next slide, please. So this is just a general overview of the petition for inquiry that I want to give you, and then Kelly's going to give you the history of the accountability, and then we're going to jump into the petition for inquiry involving GMA 16. So it's governed by Chapter 36 and the rules of the commission. A petition for inquiry is filed by an affected person that asks the TCEQ to review a district's activities concerning management, planning, and rules. And so, who's an affected person? An affected person can be a landowner within the GMA. It can be the districts that are within the GMA or adjacent to the GMA that involves the GCD. It can be the regional water planning group, or it can be a permittee. And what are the things that a petition and review can cover that a petitioner can ask the commission to look at? If there's a management plan that's not submitted, if there's a failure to participate in joint planning, if the GCD fails to adopt rules, if they fail to implement the desired future conditions, if the rules are not adequate to protect the desired future condition, or rules are not adequate to protect groundwater. So that's who an affected person is. Those are the areas that the commission can investigate. Once a petition is filed, it has to be provided to all groundwater districts within the GMA and adjacent to the GMA. There's an opportunity for the any GCD within the GMA or adjoining GMA to file a response. A response can also be filed by the respondent to the petitioner's filed against. And then if the commission decides whether or not it wants to even grant the petition, and if it does, then it will set up a review panel made of 5 disinterested persons. One is selected as the chair, and the commission representative has a non-voting position kind of as a recording secretary, more or less. So that's the overview. Go to the next slide, please. In any of these accountability remedies that I've talked about, whether it's a state audit or a management plan failure or a petition review, the commission has about 5 different remedies they can implement. They can issue an order that's like an injunction that requires actions, or ask the GCD not to take certain actions. It can dissolve the board and call for an election of a new board. The commission can ask the AG to intervene, sue, and set up a receivership for the district. It could dissolve the district, appoint temporary directors, and have new election, or it could ask the legislature to step in. So that's the overview of the process. Now we're going to go to Kelly, and Kelly's going to tell us historically how these accountabilities have been conducted at the commission.
All right, thank you, Bill. Can you all hear me? So from my recollection, the first performance review provisions were added to Chapter 36.1 in 1997. The TCEQ got our rules in place in '99, and the state auditor's office did their first pilot audit of the Gonzales County GCD in '99. And if I remember, Barry Miller said they were going to be the first to battle back at that point in time. So since then, I believe SAO has produced 13 reports auditing around 120 GCDs. So some have been audited more than once. I'm sure you know who you are. To date, SAO has found 11 districts not operational, and there are over 100 occasions where districts have missed statutory deadlines to adopt or re-adopt a management plan. Next slide, please. TCEQ's worked with these districts to encourage them to achieve compliance, and most get there on their own action, you know, with very little prodding from the commission. But many we have used voluntary compliance agreements with that provide a schedule for milestone actions to achieve clear compliance. TCEQ has been required to enforce against 3 GCDs over the years. One of them was found not operational by the state auditor's office, and the other 2 failed to re-adopt their management plans. TCEQ dissolved 1 GCD, and the other 2 during the enforcement process petitioned for and consolidated with an adjacent operational GCD. And I believe the Chapter 36 performance review petition for inquiry provisions have been amended 5 times since 1997, with most of the significant changes being made by House Bill 1763 in 2005, Senate Bill 660 in 2011, and House Bill 2767 in 2015. Next slide, please. So between 2007 and 2020, there have been 6 petitions to TCEQ for inquiries into GCD matters. In one case, the executive director and the district entered a compliance agreement to resolve the issues. 4 of the petitions have been dismissed, and 1 petition was accepted and a review panel appointed. And I'll kick it back to you, Bill.
Thank you, Kelly. At this point, Tom Koeneke will give us some background on Starr County GCD. Tom, you there?
Yes, sir. Can you hear me?
Yes, sir.
Okay. You can see from the slide that the district has had a difficult time getting started. Originally created by the legislature in '05, management plan adopted and readopted in 2014, the state auditor report in 2018. I joined the district sort of midway through all of this after the management plan had been adopted. In my view, we had several strikes against us getting started. One was the management plan that we adopted or readopted, the district readopted, was way too aggressive, required the district to do a lot of things that a startup district with no funds could not possibly do. Also, in my view, the rules were so difficult to follow that even as an attorney dealing with tax regulations, I had difficulty reading the rules. The other is that we have a county that was going through some financial straits at the time, so we really had very little access to help from the county. So this put us where we were and set us up for the petition for inquiry.
Thank you, Tom. So I'm going to give you just a thumbnail of what happened to kick off the petition for inquiry. Starr County Groundwater Conservation District is in Groundwater Management Area 16. There are 10 GCDs within GMA 16. Starr County did not attend most of the GMA meetings and did not participate in the setting of a DFC. And so the 8 of the GCDs within GMA 16, B County, Brush Country, Live Oak, McMullen, Kennedy, San Patricio, Duval, and the Corpus Christi ASR Conservation District initiated a petition asking the commission to review Starr County for 3 failures to participate. One is not participating in joint planning. They hadn't attended a GMA meeting in a couple of years. There was no DFC adopted by the Starr County GCD as a result of the GMA's adoption of DFCs, and the management plan was not updated. So that petition was filed, and I'll turn it over to Kelly to walk you through the process of how that petition was handled.
All right, so the GMA 16 GCDs filed the petition on August the 5th of 2019, and that started a 90-day clock for staff to get the matter before the commission for a decision to either dismiss the petition or to appoint a review panel to conduct the inquiry and submit a report and recommendation. Staff in our office and in our legal office began reviewing the petition. On August the 15th, the Commission General Counsel sent a briefing letter to the parties requesting any replies within 35 days of the date of the petition. I think was around September the 9th, and requesting the Executive Director and the Office of Public Interest Counsel, or OPIC, to provide response briefs by September the 20th. We reached out to Leah and tagged and solicited review panel volunteers from August 29 to September the 13th, and we got 3. And then we contacted another 7 GCD managers between September 17 and 19, and we got 5 more volunteers, which we greatly appreciated. In the September 20 response briefs, both the Executive Director and OPIC found that the petitioners had met all the procedural rule requirements, and both recommended the commission accept the petition and appoint the review panel. On October 4th, the commission's general counsel sent an agenda setting letter to the parties and outlined how the matter would be heard in Austin. On October 16th, Lloyd Gosling, Rochelle, and Townsend PC filed a notice of appearance of counsel for the Starr County GCD. And on October 26th, counsel for the district filed the district's agreed unopposed motion to grant the petition and select the review panel. On October 23rd, the commission considered the petition for inquiry for the Starr County GCD and appointed the review panel. The chairman signed the interim order appointing the review panel the following day, and that started a 120-day clock for the review panel. Hand it back to you, Bill.
Okay, thanks for that overview, Kelly. Now the real interesting part, we just talked about process really, but Lynn Smith's going to pull the curtain away from the review panel. He was a panelist. So Lynn, tell us what you guys did once it was kicked over to you. And next slide, please.
As you can see from the previous 8 or 9 slides, this process was a very formal process up until the day the review panel was seated. After that, basically, we knew we had a game to play and we knew what the end date was, but we didn't know what the rules were. Basically, when we asked, we found out there were no real rules. We wanted to know who the referees were, and we found out there wasn't really any referees either. So, okay, well, what matters? Well, the final report mattered, and the final score. So, the panelists were sort of scratching their heads and said, okay, well, that's the rules we're given or not given. So, what ball do we pick up? What game do we play on this? We each had our own ideas about how to go about the process, but when we got together and visited, I think each of us kind of changed a little bit, and we sort of developed a concept to move forward. But our first meeting was a little bit touch and go. We weren't real sure exactly where to go with this game. We did know there were plenty of spectators, though. Next slide, please.
So Lynn, while we're waiting for the next slide, the only real guidance that the statute provides is it says that you can have a hearing and collect evidence, write a report, and make recommendations. That's all the guidance you've got. So go ahead.
Yes, that is correct. And in a lot of statute, and I would dare say most state statutes, you've got the statute, and then you've got rulemaking that goes on surrounding the statute. Well, in the review panel process itself, there really never was rulemaking to define the steps, the process, and obviously the result was defined. It's a final report, but as far as the nuts and bolts of how to go forward, we really didn't know. And what we found out was we didn't really have anybody to ask, so we had to develop these processes ourselves.
Then you might describe the other members, who they were of the review panel.
Hold on, I've got to adjust my sound a little bit. Okay, speaking. Yes.
Who were your other fellow panel members?
My fellow panel members, I should have made a list of them. It was Dirk Aaron was our chairman, Zach Holland, and Joe Cooper. One more, Kelly.
It was Micah.
Micah, yes, Micah Vulgaris. I don't see Micah often. We're in different parts of the state, so I forget. So, each of us came from different size districts, different backgrounds, different professions prior to being general manager. So we all had our own idea about how to proceed. So we looked at just, our meetings. Are they private or public or something in between? Deliberations of our panel after those meetings, are they private? Providing evidence to the panel. Is that something that we could insist on, or is that something we just had to ask nicely? Interviewing witnesses. We really didn't know. We thought we could probably ask people questions, and we did, but that wasn't really something that was spelled out for us. Conducting hearings. There is a discussion of a hearing in the statute. We conducted something. I'm not exactly sure what we had. It was certainly a meeting. So we could probably move to the next slide here, Bill.
So Lynn, talk about the interactions you had with Starr County representative and the other GMAs that you sent out what was the equivalent of interrogatories, and talk about the couple of hearings that you had.
Yes. We decided that we wanted to collect some evidence. Now, a fair amount of the evidence, in fact, probably enough evidence, had already been collected and summarized by the state auditor's office. But we believed as a panel that we should go back to the original people, the petitioners, Starr County. There were a few other people, and we asked some fairly specific questions and received written responses from all of those people. So we never did really answer the question of, is it voluntary to give evidence to the panel or is it required? We received all the evidence that we asked for.
And then explain the hearings that you had, one in the local area and one in Austin.
Well, I'm not sure if we had a hearing, Bill. We had a meeting and we thought it was a hearing, but we were told maybe it wasn't a hearing. It was an interesting discussion. So I'm going to call it a public meeting with specific people invited to hear what they said. And we had that meeting in Starr County so that the local individuals, board members, members of the public, a state representative was present, and we got to listen to each story that they had to tell and ask them some specific questions. I felt like that was very useful to the panel.
And it's fair to say that Starr County was very cooperative during this whole process.
Yes, absolutely. Absolutely.
And then you had a hearing in Austin as well, or a meeting, however you describe when y'all got together. Talk about that in Austin. Well,
after, of course, we had several meetings. Most of our meetings were virtual just because we were scattered across the state. We had the face-to-face meeting there in Starr County. Then we had another informal meeting at a tag meeting, and then another in-face meeting. We'd call it a hearing at TCEQ. And really the purpose of the last meeting that we had at TCEQ was to kind of lay out what the panel's recommendations were, and also, of course, to get together and kind of finalize that final report that was due.
Did you have an attorney or any other assistance from third-party sources to help you?
No, we had the opportunity to ask what we called procedural questions from the Office of Public Interest Counsel and also from Kelly's office. And we got answers on some of our questions, which were procedural, but a good number of the questions that the panelists felt like probably were procedural questions, we weren't provided answers for. The various attorneys suggested that those weren't procedural questions. They were actually, I guess, related to the process at hand, but not necessarily the procedure at hand.
So in the final report, there was a set of recommendations that basically have been negotiated. My recollection is that Starr County initiated the proposed remedies that they would conduct to get this behind and to come into compliance. Is that how that? Isn't it correct that Starr County sent out a proposal saying this is what we'll do, and then there was a process of vetting that with all the petitioners and the review panel and TSEC?
I would say that the review panel was involved at the outset of that. And, you know, one of the things that we were not really made clear of, but we finally vetted out on our own, was there is the possibility of a negotiated settlement being brokered more or less by the review panel in the absence of TCEQ. And we considered that. We decided not to do it in the absence of TCEQ, that we wanted TCEQ involved for follow-up purposes. But the panelists were involved at the outset of that. And we really didn't have any pushback on that at all. I think that Starr County wanted to be involved in what they were going to be required to do. And it also allowed the petitioners the opportunity to look at that and say, yes, that's what we want, or no, we want something added. And we were able to pull that together, include that in the report as a recommendation to the executive director, which I think was very instrumental in really an opportunity for GCDs to have a bit more control over what happens within our own group or our own industry.
So Lynn, I think we kick it over to Kelly and let him talk about the outcome, unless you have something else you want to add before we do that.
No, not at this time.
Okay, Kelly?
All right, so the review panel did meet the 120-day deadline, and they filed their report and recommendation with the commission on Valentine's Day 2020. That started a 45-day clock for commission action to be taken. And I kind of messed up on my next two errors, and I didn't catch it until yesterday. So on February the 28th, the commission's general counsel sent the agenda setting letter to the parties. He requested that the executive director to file his recommendations regarding the review panel report by March 6th, and gave the other parties opportunity to file responses by March the 13th. On March 6th, the executive director filed a draft order to implement the review panel report recommendations. And on March 13th, counsel for the Starr County GCD filed a response requesting 2 changes to the draft order. And the executive director did not oppose either of those changes. The commission considered the matter at agenda on March the 25th and approved the order with the changes. We were item 1 of their first virtual agenda meeting, so that was kind of interesting. And then Starr County is now operating to implement the provisions of the order and providing milestone updates to TCEQ. Bill?
Kelly, do you recall, or do you have the order in front of you where you could tell folks what the solutions were for Starr County to implement?
Whew, I don't have the order in front of me, and the negotiated settlement laid out pretty much the path forward for Starr County to hit all of the marks to achieve compliance. So, and Starr County, to their credit, they had hit a bunch of the marks already that were laid out in the negotiated settlement. So the order basically acknowledged the marks that had been hit and then laid out a time frame for the district to hit the rest of the marks.
So my recollection is that some of the things that Starr County is doing as a result of this, and Tom, feel free to step in, or maybe you want to take this.
Sure. We out of that negotiated settlement and the order that was entered, we've been able to really make a great deal of progress. Basically, it provided to us through the panel and TCEQ really all the guidance we needed to become fully in compliance with the regulations. And I have to say that we couldn't have done this without our attorneys, Mike Gershon and Cole Ruiz, who were instrumental in guiding us through this process as well, and helping us with the appropriate responses to all the inquiries that were made, in essence, the interrogatories and the like. And I think that the gist of what happened provided the mechanics and the push that the district needed to move. And I think so far we've been able to meet all the required deadlines. And I think it's really helped us to become very involved and aware of what we need to be doing.
And that's right. And some of the things I recall was that the district had to provide a schedule for their next elections. They had to update their rules, had to update the management plan. I think one of the, and then provide evidence that it was participating in the joint planning. And then I think one of the most interesting and creative things dealt with financing, and the county and the district got together through an interlocal or other agreement to provide office space and financial support to the district, if my recollection is correct.
Yeah, that's correct. The county judge and the commissioners have been very supportive. We do have our office open. We have a website. We have hired a executive director, executive manager. We are working with the county. They're still providing support for us until we can have the tax election.
And I think many of the requirements that the commission ordered that came out of the negotiated settlement had been accomplished by Starr County before the order was even entered. So it was a very cooperative process. We've got about 10 minutes left. Let's go to the next slide and talk about what lessons were learned as a part of this. So, Lynn, I think you put this together. What do you think worked well from your perspective as a panel member?
Well, we utilized GCD managers, GCD staff to solve a GCD problem. And I think that was important to show that we were capable of, and no offense to Tom, but that we basically tried to police our own as best we could within what was legally offered as available to us.
And what, Kelly, from the commission's perspective, what do you say worked well?
I can think of a few things that worked well. I think the statutory guidance is pretty clear for the commission to get to its decision point to either dismiss or appoint the review panel. And I think it's pretty clear for what the review panel report was supposed to include. I do think the review panel members brought a ton of GCD management experience and expertise to the table, and each member had a very unique understanding for what it took them to run their very different districts. So I think that was very beneficial. I think that the review panel did a great job working through procedural matters without much statutory guidance and trying to be inclusive and transparent, working through the information and evidence. And I think they adopted and submitted an excellent report to the commission. I did want to give a shout out to Peggy Hunka with TCEQ. I thought she did an outstanding job as the panel's non-voting recording secretary. And I think Starr County GCD's retention of counsel and full engagement from that point on was critical to the success that I think we saw. And lastly, I think the panel and the district's negotiated settlement will be a huge resource if anyone ever has to go down this path again. So I think those were the things that kind of worked well.
Tom, do you have anything to add on what worked well?
Well, I think what worked well is we can see from the progress the district has made that it has worked well. We're starting to get up and running. We do have a new management plan. We have revised rules. As I said before, we have an office open. We have someone running the office. It's apparent that the process has worked to get us up and running.
Okay, well, let's talk about where there may be something to improve then in this process. Let's go to the next slide. And then this slide and the next. Let's go to the next slide as well. Just go ahead and throw it up. Let's talk about where we can improve things. Lynn?
Bill, you want me to take this one?
Yeah, go ahead.
Okay. You know, we had the things that we felt like were kind of so-so. Peggy did a great job with her piece of this, but had it been a different circumstance, or had it been a different person, we weren't real sure exactly, with TCEQ being the ultimate authority over GCDs. Do you have a GCD employee as being a disinterested? We weren't real sure if that really was a reasonable expectation. There could be some improvement there. You know, the things that were really kind of bad was the lack of legal representation. And, you know, I won't say that our legal representation was an unfunded thing. It was really self-funded, because we did, in some cases, go out and seek legal representation. Where we ran into problems with that was, you know, did our local districts where we each came from as panelists have the funds and the willingness to fund a state project, basically? And, you know, that's a different discussion. And then just the financial support, you know, motel nights, travel, staff time, all of that cost money. And all of our local boards were willing to spend that money to address this issue. However, this was really a pretty straightforward issue. So we didn't have a lot of travel. And the report, while it was fairly extensive, it didn't take a terribly long time to create. The next situation, which comes before a review panel, may be different. It may be more complex. There may be a lot more time involved. And because of that, these two issues here may need to be addressed in some manner.
Kelly, do you want to add anything to ways to improve the process?
Well, you know, Lynn's absolutely right. You know, everybody had legal counsel except the review panels. So, you know, that was pretty challenging. And as parties, you know, legal counsel for the executive director and OPIC were only able to provide, I mean, limited guidance to the panel regarding matters, you know, on open meetings and open records and notice questions, and, you know, service list questions like that. And I don't really know what the answer is. Maybe the panel could solicit a volunteer counsel from one of TAG's associate members, I'm thinking.
There you go.
You know, and I do think the number and the purpose and procedures for the panel's public hearings and notice responsibilities and requirements, I think that could be clarified. I think it would be very beneficial to clarify that. And also think statutory release of liability for the panel members would also be beneficial.
Tom, do you have anything to add on ways to improve the process?
Sure. You know, yeah, I'll second the view that it was expensive, and it also compelled us to do things in a very short period of time. So it took a lot of effort and time from all of us who were involved. There was one member of the district, one of our directors, who felt like the same thing could have been accomplished with something that we would use in the legal profession, like a demand letter. Instead of filing the petition for inquiry, could there have been some sort of demand sent to us before the petition was filed to clear all this up? I'm not so sure that would have had the same effect, because Lynn and the other members of the review panel, as well as TCEQ, I think really helped us get on the right track. But that I did want to mention that there was a feeling by some of the folks involved that the petition may not have been necessary.
So I think we've probably covered final takeaways as a part of what's good and what's bad. You know, I would add that I think it worked very well, and the parts that were identified that need improvement, I think those would really be highlighted if we ever have a situation where one of these petitions is granted and people are not, and the parties are not cooperative. Then the lack of an attorney, the lack of guidance, the lack of funding will really come into play. And so anybody else have any final takeaways? We've got about 2 minutes for questions.
I've got 3 quick things I wanted to throw in before we go to questions. You know, I wanted to say thanks to Leah and Tag for helping us solicit our review panel members on the front end. And I know at agenda, before they adopted the order, the commissioners, OPIC, and the executive director all expressed their gratitude for the time committed and the excellent service of the panel members. And I want to take this chance to be on the record to say that Lynn, Dirk, Zach, Micah, and Joe B did an outstanding job, and that I greatly appreciate them as well. And then I just wanted to let Lynn know that I'm still working on the Chick-fil-A gift cards.
It's a little bit of an inside joke. I kept looking for my envelope with the Chick-fil-A gift card from the executive director. It hasn't happened yet. I don't know that it will. We'll see. And I too would like to thank my fellow panelists or review panel members. I really felt like I was by far the junior member on that panel. I was among some very well-respected, very well-versed, very experienced people, and I learned a lot through that process myself.
Bill, let me just say also to reiterate how much we appreciated the help and assistance from the review panel. And each one of them made it clear that whatever assistance, help, questions that we needed to have answered, they would help us answer, and they did. So I do want to give them a very special thanks for doing that.
All right, thank you, Leah. We're back to you.
Yes, and I apologize again for our technical glitches getting this panel up and going, but despite all of that, there has been a lot of interest and a lot of questions that came in, and I'm gonna go over a little bit here into our break just because I wanna make sure that we get some of these answered. Kelly, one question I think really goes to something you mentioned regarding some clarifications that would be helpful. You know, do you think that there is a need for TCEQ to undergo a rulemaking, or otherwise have there be statutory changes to address some of the questions, or, you know, these unanswered questions where there's not guidance?
Yeah, you know, and I think the agency is very cautious of writing rules when we don't have a whole lot of statutory clarity on, you know, on what the procedures need to look like. So, you know, certainly if there were some statutory clarity made to the process, that would certainly make it very easy on the commission to fill in the gaps.
And Kelly, another question that had come in for you was, how is TCEQ going about monitoring Starr County's compliance and implementation of that negotiated settlement in the order that came out of it?
So in the order, you know, they have basically quarterly check-ins where they're submitting us their minutes and the associated documents so we can track what they're doing. And, you know, we're given a little bit of grace in the time of COVID because, you know, they got started right when everything went to pieces. So, but they're, you know, they're sharing information with us, they're moving forward, and we're just we're trying to work with them like we would try to work with anyone else.
Mm-hmm. And then this is a question I think mostly for Lynn, but I'd be curious to hear Tom's thoughts on it as well, about whether or not after having gone through this process and served on the panel, would serving on a panel in the future be something you would consider?
I would consider serving on another panel, yes. Now, having experienced it, I understand that it's not really a scary process, but as I originally had thought it might be. However, it would be nice to address some of those little tidbits that we had some questions about as we move forward.
What about you, Tom? Having been kind of on the other end of it, would you in the future consider participating in a process like this on a review panel?
Wow, that's a very difficult question. I know how much work these folks put in. I'm not sure I have the expertise to do that. I'm just learning. I don't think I have really the experience that the review panel has had. Maybe sometime down the road, when I've been involved for a longer period of time, but you know, at this point in time, I really don't think I would be qualified.
And then Bill, someone had asked about your role in the process. If you could maybe just take a minute to share with everybody how you engaged with the petitioners and their perspective.
So my actual client in this matter is Brush Country Groundwater District that is a member of GMA 16. So, you know, I helped put together the petition and get the ball rolling. And then probably after that, most of the work was done. Any work that needed to be done by the GMA petitioners, questions answered, interrogatories responded to, they did it themselves. So I just got the thing rolling.
And I think that raises, you know, another point when we're thinking about the financial aspect that your clients had to expend resources in order to get that ball rolling.
That's right.
Yep, yep. And then maybe one last question. Was the timeline too aggressive? Lynn, maybe you would be the best position to speak to that first, having been doing that work on a short time frame for the panel.
I'm sorry, can you ask the question again?
Was the timeline too aggressive in order to complete the work of the panel, that 120 days?
You know, I think for this particular situation, it was adequate. If it were a more complex or contested issue, I think that it would probably not be adequate. And really, the time frame is not flexible in the statute. Mm-hmm. So at the end of the time, that panel would have to submit a report. That report might just be one page that says we're not finished yet. I don't know how that would fly with the executive director, but that might well be a problem if you don't want to extend things too long. But I think that if it were contested, it would not be adequate time.
Wonderful. Well, thank you all. This has been a really interesting panel. There are more questions, but we're a bit over time here. So I really appreciate you sticking with us, coming and being a panel part of the summit and sharing your experiences serving on that review panel and being involved in that process. So thanks to you all.